Good afternoon to everyone joining us today. On behalf of the Department of Law, Central University of Karnataka, I extend a warm welcome to all participants to the eighth lecture of our ongoing marathon series of 100 online lecture under the flagship initiative mission Nyayadrishti Samvad. Today's session promises to be intellectually stimulating as we delve into a crucial constitutional subject, a doctrine of occupied field, a critical analysis. It is my privilege to introduce today's distinguished speaker, Dr. Juri Goswami, Assistant Professor of Law at JP Law College, Guwahati, Assam. About Dr. Juri Goswami. Dr. Juri Goswami is an assistant professor law at JB Law College, Guwahati, Assam. University Law College, Guwahati. University with first class, first in IPR specialization. The author has also secured first class with distinction with specialization in international environmental law from Amity Law School, Noida. She has the honor of being the first doctorate degree holder from National Law University and Judicial Academy, Assam for her thesis Efficiency of Wildlife Protection at 1972, a study with special reference to Kaziranga National Park, Assam. Her first book was published and inaugurated on 11th September 2025 by Kaziranga officials entitled as Wildlife Law and Kaziranga National Park. In this book, an attempt has been made mainly to discuss about the law in the field of wildlife preservation in international and state Assam level with special reference to Kaziranga National Park, Assam. She has also cleared state level eligibility tests in law with rank 6. The author has her contribution in different journals, newspapers, magazines, and she has visited her presented her research work in the field of wildlife at various national and international platforms. She had received initiative from Wildlife Conference held in very recently from Oxford Central from for Animal Ethics on March 19, 2025. For her research work in the field of environmental and wildlife laws, she has 15 years of experience of teaching law in different law colleges and universities in Assam. With great respect and authority, I now invited Dr. Juri Goswami to deliver her talk with a doctrine of occupied field, a critical analysis. Ma'am, the virtual floor is yours.
Thank you. Am I audible to everyone? Is my voice is clear or it's breaking?
Yes, ma'am, clear, ma'am.
Uh, so, in the words of Dr. B.R. Ambedkar, the Constitution is a vehicle of life and its spirit is the spirit of age. A very good afternoon. Namaskar. I am Dr. Juri Goswami from Guwahati, Assam. I am here not to deliver an expert lecture, but to discuss and focus on a very, very important aspect of our constitution, which I feel very significant in reference of passing of any legislature by the union as well as by the state legislature. So at the outset, I congratulate respected Vice Chancellor sir and the entire respected faculties of Karnataka Central University Department of Law who are associated with Mission Nyayadrishti Samvad. It's an outstanding step of Central University of Karnataka Department of Law for organizing this lecture series on the different aspects of the Constitution of India, which we considered as a living document. My heartfelt gratitude at the outset to the organizers for inviting me for today's lecture, and the most especially my student Jayanta, working in this prestigious institution. We all are proud of you, Jayanta. So thank you for giving me this opportunity so that I can share my thoughts with the audience. So the today's topic of discussion, as ma'am has already told, that a doctrine of occupied field and analysis. So in my lecture, what I would like to cover, I would like to share my synopsis of the lecture. An introductory note will be there on the subject, doctrine of occupied field. Next, I would like to focus on the relevant provisions of the Constitution of India. I would like to focus doctrine of occupied field in details, but along with the doctrine of occupied field, there is other more important doctrine which is relevant in this context, which we know as doctrine of repugnancy. And what is the core difference between these two doctrines, occupied field and doctrine of repugnancy? And my lecture, so in my lecture, I would like, and there will, my lecture, I will also like to discuss the judicial role while interpreting these doctrines of the Constitution of India. So I hope the listeners will enjoy the lectures, and which will be an not a one-way session. Everybody must participate, and please open up. So first of all, while sharing an introductory note on the subject, so I must say that the distribution of legislative powers between the center and the states, which is a very essential feature of the constitution of a federal state like India. So the object of such a federal constitution is to establish a dual polity involving division of authority between whom? Between the center and the separate state governments. So one is not subordinate to the other in its own field. There is coordination between these two authorities. So in fact, the basic principle of federation, as we all know, is that the legislature, executive is divided. Financial authority, legislative, executive, financial authority is divided between the center and the state, not by any law passed by the legislature, but by the constitution itself. So, as we all know, we must have to refer the Government of India Act 1935 introduced a scheme of threefold enumeration, namely federal, provincial, and a concurrent list. So the present Constitution of India follows the method adopted by the Government of India Act 1935 and divides the powers between the states in three lists: union, state, concurrent. So union list having 100 subjects, which is of national importance. State list 61 subjects like local government, public health, sanitation, agriculture, etc. And the state has exclusive power to make laws on the subjects enumerated as well as the mentioned in the state list, as we all know. The concurrent list have 47 subjects. Sorry, 52 subjects right now. So both the center and the state can make law on the matters enumerated in the concurrent list, as we all know. And in case of a conflict, and in case of a conflict between the center and the state on any concurrent subject, the central law shall prevail. So the concurrent list is usually not found in the federal constitution. But the framers of the constitution have added this list to secure uniformity in the main principles of law in the state. It has been devised to avoid the excessive rigidity in the distribution of power between the center and the states. Here I have to mention one very, very interesting quotation, interesting phrase used by M.V. Pillai, constitutional expert. So, according to him, the concurrent list is a twilight zone. So, the term twilight zone in reference of the concurrent list of the Indian Constitution. So, this phrase describes the unique nature of the concurrent list of the Constitution of India, which includes subjects upon which both the union and the state have the power to make laws. So the twilight zone basically highlights for less important matters, states can take the initiative in legislation. More important matters, parliament can do so. The list acts as a device. This concurrent list acts as a device to prevent excessive rigidity in the division of power between the center and the states. And in the event of a conflict between the central law and the state law on a subject in the concurrent list, we all know the central law will be prevailing, as outlined in Article 254 of the Indian Constitution. So here, in this context, in the context of distribution of power, legislative power between the center and the states and the list, union, state, and the concurrent, the doctrine of occupied field finds a very relevant place in the discussion. So, doctrine of occupied field is basically, in short, if I would like to say, that is mainly focused on existence of legislative power. And doctrine of repugnancy, as I have already told, that which is also a relevant aspect in this context, is mainly dealing with exercise of legislative power. So one is existence of legislative power, occupied field. Repugnancy is exercise of legislative power. So now, in this context, what are the relevant constitutional mandate we must have to discuss? So in this context, we must have to discuss Article 246, 7 schedule, talking about division of subjects into 3 categories, union, state, and concurrent list. So 7 schedule contains the list of subjects contained in this list. So in this context, in this discussion of occupied field, we must have to discuss 2 very, very important articles, 246 and 254. So 246, the area of legislation of the union and the state, which has been defined in Article 246 of the Constitution, is talking about that Parliament has exclusive power, 246 Clause 1, exclusive power to make laws in respect of a matter enumerated in the union list. Clause 2 is about that both the Parliament and the state can make law on the concurrently subject, and another emphasis of this section was that state has exclusive power for the subjects enumerated in the state list. So Parliament has power to make laws with respect to any matter for any part of the territory of India, not included in the state, notwithstanding that such matter is a matter enumerated in the state list. So however, the problem is not that severe, as it is the rule of law which always comes into play in the event of both the central legislature and the state legislature enacting a law on the common subject. So in such a case, both shall be enforced, and in case of any inconsistency between the 2 laws, the one enacted by the central legislature will definitely prevail. And the doctrine of repugnancy in this context comes into play. So doctrine of repugnancy, as I have already told, very closely related to doctrine of occupied field. A mention of Article 254 dealing with the doctrine of repugnancy is very, very worth mentioning in this context. So Article 254, One, I have discussed Article 246, 246, now 254. 254 is also very, very relevant, which talking about inconsistency between laws made by the parliament and laws made by the legislature of the states. So these are the two important articles which are relevant in this context. We have discussed introductory part, we have discussed relevant articles of the constitution. Now, directly I would like to explain what do we mean by the term doctrine of occupied field. So it's a legal principle stating that if a national government has enacted a comprehensive law on a subject, a state or local government cannot pass its own law on the same subject if that law conflicts with or obstructs the national law. So this prevents legislative overlap and maintains consistency, especially for subjects listed under concurrent list, because concurrent list is a list where both can legislate. So where both levels of government can legislate. So once Parliament pass an act, the field is considered occupied. Occupied by whom? Occupied by Parliament of India. And any state law on that matter is restricted. Here I would like to cite one example. So we can imagine one person has already claimed for a specified seat. Okay? So no one else can sit there, even if they do not plan to interfere with the first person. So he has already occupied that field. So there are certain important features of this doctrine of occupied field we must discuss, that it clarifies jurisdiction in a federal system by preventing one level of government from encroaching on another's legislative authority, number one. Number two, it establishes that a national law takes precedence even if it has not yet been notified in a specific state, and the state law that is inconsistent with it is considered void to the extent of the inconsistency. Third, while both the national and the state governments can legislate on matters in the concurrent list, the national law will definitely prevail if it is comprehensive and the state law creates a conflict. So the very purpose of this doctrine is to avoid conflicts of laws, ensure legal certainty, and maintain harmony between the different levels of the government. So while discussing doctrine of occupied field, we must discuss what is the contemporary relevance of this doctrine. So number one, while discussing contemporary relevance, so this doctrine remains a fundamental tool. It still remains and it will remain a fundamental tool for maintaining the balance of power between the union and the state governments, ensuring that one level does not overstep its constitutional authority. Number two, it is consistently applied in contemporary legal cases involving new and complex issues, ensuring that laws related to areas like technology, environment, economic policy do not conflict between different levels of government. And lastly, I must say it plays a very, very important role in determining the validity of legislation, as challenges to law often involve arguments that a state legislature has encroached on a field already occupied by a parliamentary legislation or the act. So, as I have already told, as I have discussed doctrine of occupied field, now I'm going to discuss how we can discuss the doctrine of repugnancy in this context. So doctrine of repugnancy, as we all know, it's a legal principle that resolves conflicts between laws passed by different legislative bodies such as central government and the state government. So the field refers to the subject matter or area of law that is being legislated on. Repugnancy arises when two laws, one from the central and one from the state legislature, cover the same field and have conflicting provisions that make it impossible to obey one without violating the other. So when this happens, the central law prevails over the state law to the extent of the conflict. Here, doctrine of repugnance, here also I would like to cite an example. Say, for example, two people have tickets for a same seat in a bus. Ticket. So whichever ticket is valid or was issued first takes precedence. One of them must have to give up the seat. So first come first. So doctrine of repugnancy, while discussing doctrine of repugnancy, there are also certain key aspects in this context. So this doctrine is most relevant when laws are made for matters listed in the concurrent list of powers which both the central and the state governments can legislate on. Repugnancy exists when two laws are so inconsistent that one cannot be followed without breaking the other. Third, when a state law is repugnant to a central law on the same subject, the central law takes precedence and the state law becomes void to the extent of repugnancy. And there is one more important aspect that presidential assent is essential. So a state law that is initially repugnant to a central law can be enforced in that state if it receives the president's assent. So if the two laws operate in different fields, that is, deal with different subjects, the doctrine of repugnancy does not apply in that context, even if the subjects are related. But the thing is that both are two laws operate different on a different subjects. So in that context, doctrine of repugnancy will not come into play. There is a very very thin line of difference between these two doctrines. So the core difference is that the doctrine of occupied field concerns the existence of legislative power, preventing state laws on a subject where the central government has already legislated, while the doctrine of repugnancy deals with the exercise of that power and resolves conflicts when both central and the state laws are inconsistent. So repugnancy arises when a state law directly conflicts with a valid central law on a concurrent subject, making the state law void to the extent of repugnancy. So the focus of doctrine of occupied field is the legislative competence. Who has the power to legislate? Right? So doctrine of occupied field, when a central law occupies a legislative field, it means the central government has exclusive authority over that subject and the state cannot legislate on it all regardless of conflict. The conflict is here in case of doctrine of occupied field. The conflict is not between the two laws themselves, but between the state's attempt to legislate and the central government's established legislative authority. So here the conflict is not between two laws themselves. But in the context of doctrine of repugnancy, the focus is inconsistency between law. Who has a right to legislate on a subject that both have the power to legislate on? So the doctrine of repugnancy, it resolves conflicts between valid central and the state laws on subjects in the concurrent list. The central law prevails and the state law is void to the extent of inconsistency. And here, in case of doctrine of repugnance, I'm telling the conflict is direct and explicit between the provisions of two valid laws. So in case of occupied field, as I have already told, not between the two laws themselves, but here in this context, the conflict is direct between the provisions of two valid laws. So this is all about a discussion on doctrine of occupied field and doctrine of repugnancy. Now, here in this context, we must discuss certain important case laws in this context. So, there is a famous case of 2012, State of Kerala and others versus Mar Apramem Kuri Company Limited and others. So, what has happened to that case? The center, the Union Parliament, has enacted the Cheat Funds Act, which is a central act. For the law to become operative in any state, the central government would have to issue a notification under Section 3 of the Central Act. So, in the meantime, the state of Kerala enacted a separate legislation on the cheat funds called as Kerala Chitties Act. So, however, the Central Act did not get notified in Kerala, resulting into a situation wherein there was only one act in force in the state of Kerala, that is the Kerala Chitties Act. So it was contended that the Kerala Chitties Act was repugnant to the unnotified Central Act, and it engaged to persuade a division bench that the Kerala Act was repugnant to the unnotified Central Act. So the state of Kerala appealed, and the Supreme Court referred the matter to a constitutional bench. So surprisingly, what has happened that the constitution bench accepted the contention of the cheat funds that even an unnotified central law attracts Article 254 of the Constitution of India. So the Chief Justice gives two reasons for this consideration. Number one, that Article 254 uses the verb made, wherein the making of the law is complete by the enactment and the question of notification does not arise. Number two, Parliament, by enacting the Central Act, intended to occupy the entire field falling in entry 7 of list 3, and therefore the state legislature is denuded of legislative competence unless Article 254 clause 2 is applicable. So that was a decision from the Apex Court of India. But there was several discussions in this context, and it was submitted that this decision of the Apex Court is incorrect and unfortunately conflicts occupied field and repugnance. So critics have highlighted that first, the verb made is used as senior counsel rightly submitted in oral argument not to indicate when a law becomes repugnant, but to identify the law which must independently be shown to be repugnant. And secondly, the conceptual distinction between repugnance and occupied field, or between the existence of legislative power and its exercise, is at the heart of the Constitution's distribution of legislative powers. To hold that a mechanism is intended to solve such conflicts is applicable because the field is occupied. So thus, the state legislature is denuded of legislative competence as soon as the Parliament, by enacting the Central Act, intended to occupy the entire field of cheat funds under the concurrent list. So this is one of the very, very important discussion of 2012 State of Kerala case, famously known as State of Kerala case on cheat funds. So one more case that we can discuss in this context is Dip Chand versus State of Uttar Pradesh. So the validity of Uttar Pradesh Transport Service Development Act was involved in that case. So what has happened? What had happened that by this act, the state government was authorized to make scheme for nationalization of motor transport in the state. The law was necessitated because the Motor Vehicles Act 1939 did not contain any provision for the nationalization of motor transport services. Later on, in 1956, the Parliament, with a view to introduce a uniform law, amended the Motor Vehicle Act 1939 and added a new provision enabling the state government to frame rules of nationalization of the motor transport. Now, here the central law, which is prior law, has already occupied that field, though it was inadequate and did not provide nationalization of the motor transport in the state. The court held that since both the union law and the state law occupied the same field, state law was void to the extent of repugnancy to the union law. So in this case, both the doctrine of occupied field and doctrine of repugnancy comes into play. But even if a particular
కాదు గోకులు
legislation,
మీ గుంటూరు ఆ సైడ్ అంతా బాబాయ్ బాబాయ్ అని అలవాటు.
yes,
అరే మీరు బాబాయ్ లేరా అనేది ఎక్కువ. బాబాయ్ బాబాయ్.
hello, hello,
Ramakrishna, please mute.
hello,
ఇది ఎండ కొడుతుంది.
hello,
టేబుల్ చైర్ తీసుకురా చాలు.
hello.
Ramakrishna,
అది కిందది ఏందిరా అది?
sorry ma'am for interrupting ma'am. Can you proceed now?
Okay. So, but even if a particular legislation of the parliament has occupied a particular field, so and it should not repugnant to the central legislation. So it will not repugnant to the central legislation. Also, the state legislation must fulfill another requirement stated in clause 2 of article 254 of the Constitution of India. So this deals with the assent of the President of India. But this shall not prevent the Parliament from enacting at any time any law with respect to the same matter, including a law aiding to, amending, varying, or repealing the law so made by the legislature of the state. So, moreover, if both the laws, that is the central law and the state law, occupy the same field, the state law shall become void and the central law shall prevail. So, in this context, one more important case we have to discuss. Jawaharlal versus State of Bombay. That was a case, I think, from in the year 1954. Right. So this Jawaharlal case is also relevant in this context. So Parliament enacted in this act. This is the discussion. This was the discussion that Parliament enacted the Essential Supplies Act 1946 for regulating production, supply, and distribution of essential commodities. So a contravention of any of the provisions of the above act was punishable with imprisonment up to 3 years or fine or both. In 1947, considering the punishment inadequate, the Bombay legislature passed an act enhancing the punishment provided under the central law. The Bombay Act duly received the assent of the President of India and prevailed over the central law and became operative in the state of Bombay. However, in 1950, when Parliament amended the Act of 1946, and enhanced the punishment, so it was held that as both occupied the same field, center as well as the state, in regarding enhancement of punishment, so the state law became void as being repugnant to the central law. So this Jawarbai case, then Kerala case and Divchan case, which I feel is relevant while interpreting the doctrine of occupied field as well as the doctrine of repugnancy. So as we have understood, the doctrine of occupied field has nothing to do with the conflict of laws between the state and the center. It is merely concerned with the existence of legislative power. And as I have already told, repugnancy is mainly concerned with exercise of legislative power. So, doctrine of occupied field comes into picture even before the union law and the state law has commenced. Under Article 254, as soon as union law receives assent of the president, it is said to be a law made by the parliament. Actual commencement of law is not important for the purpose of attracting the doctrine of occupied field. So here we can easily see that the line of difference between these two doctrines is very thin. So where occupied field ends, the doctrine of repugnancy starts. So Parliament is indeed the supreme lawmaking body under the constitutional scheme. So normally the courts try to construe a central law and a state law harmoniously. But however, when the Parliament tries to occupy the field of the state law, it is the central law that is to prevail. And here the question of repugnance is a separate one. Whether the whole state law or only a particular provision is repugnant to the central law is a question that it is to be decided after deciding whether the parliament has really occupied the field of the state law. So the intention of the parliament can be either expressed or implied. So express intention can be shown explicitly by enacting a central law to repeal a state law. But the implied intention is slightly more complicated. So implied intention can be shown by enacting a central law on a subject on which the state has already legislated. So by enacting such a central legislation, it will be implied that the parliament intends to occupy a particular field and strip the state legislature of its power to legislate in this respect. So therefore, the judiciary must be very, very cautious in interpreting the provisions of the constitution and applying the doctrine of repugnancy, occupied field, while practically applying these doctrines. So in this context, uh,
Ma'am?
am I audible to everyone? Am I audible?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Oh, I'm due to some technical issues. So
Okay, ma'am. Now,
yeah. Okay, sorry, sorry. So here I would like to conclude my discussion by saying that the general concept of occupied field refers to the situation, as I have already told, where two legislative authorities having jurisdiction or legislative competence to legislate over one particular subject or field so legislate. When the superior legislative body or authority has already enacted legislation on the subject or field, regardless of the fact whether it is exhaustive or otherwise. So it preludes the remaining legislative body from enacting any law thereon. as the field is already occupied by others. So in India, this problem is particularly prevalent in the sense that the constitution has created two types of legislative authority. One is center, which is paramount legislative authority in the country, and the various state legislature, which are each the paramount legislative authorities in their respective state governments. Though the constitution has laid down in the seventh schedule three lists which pertain to the sphere of legislative competence of the state legislative authorities, but the conflict of laws made by both the sphere is inevitable. So this is because center gets privilege over the state subjects in the concurrent list, and also upon the subjects in the state list. As we all know, under exceptional circumstances, center can also interfere on the matters enumerated in the state list. So occupied field has nothing at all to do with the conflicts between the two laws. So also in India, it cannot be said that it cannot be said the doctrine of occupied field strictly itself to the concurrent list. So we cannot tell that it is strictly restricts itself to the concurrent list. So I have already discussed the application and relevancy of this doctrine. So there could be obviously be instances where it could relate to the other two lists also, doctrine of occupied field. We cannot restrict that doctrine of occupied field with the concurrent list. It has a relevance in respect of other two lists, state list as well as the union list. So a few legislative entries in list 2 of schedule 7, which are expressly made subject to a corresponding entry in list 1 or list 3. So the two most important instances of such entries are entry 24, list 2. The subject is industries, made subject to entry 52, list 1, which provides that Parliament may declare by law that the control of a certain industry by the union is in the public interest. I hope you are all are getting what I would like to say. We cannot restrict doctrine of occupied field only in the context of concurrent list. It has its relevance in respect of the discussion of the union list as well as the state list. Here I am giving some examples. And entry 23, list 2, mines and mineral development. So made subject to entry 54, list 1, which provides that Parliament may by law declare that the control of mines and mineral development by the union is in the public interest. So by making such a declaration, the Parliament acquires legislative competence over what would otherwise be a field of the state legislation, and the state is entirely denuded of legislative competence. So it is very, very clearly apparent. It is apparent that in these cases, no question of repugnance arises, and it is only that a field is validly occupied, and consequently that field ceases to form part of the state list. It can be so expressed that the particular field is subtracted from the state list and added to the union list. So in that way, I would like to conclude my lecture. So I hope you all have understood what I would like to say. It's a very, very small concept, not a bigger one. So in conclusion, as I have already told, I have discussed an introductory note on the area. When we will discuss the doctrine of occupied field, doctrine of repugnancy, we must have to go to the discussion of the list. Union list, state list, concurrent list. What we mean by doctrine of occupied field, as I have already told, doctrine, what is the thin line of difference between this two, doctrine of repugnancy as well as doctrine of occupied field, because one is related to existence of legislative power and other one is exercise of legislative power. So there is a very thin line of difference between these two concepts. Along with this, we have also discussed the relevant case laws in this context and contemporary relevance. So, and at last, I have concluded my speech by showing certain instances so that we will not discuss doctrine of occupied field only in the context of the concurrent list, because while discussing the doctrine of occupied field, we must have to refer union list as well as the state list, which is also relevant in this context. So thank you all. And lastly, I would like to again congratulate and my heartfelt gratitude to everyone for giving me this opportunity to share my thoughts on this subject, on one of the significant subject related to our Constitution of India. Thank you.
Thank you very much, ma'am, for that insightful and comprehensive analysis. We will now open the floor for question and interaction. Participants are requested to either type their question in the chat box or use the raise hand feature to speak.
If you do not have a question that may I can ask anything to anyone, is it permissible as we have 10 minutes of time?
Okay, ma'am. Moving
So,
on, ma'am.
yes, Harshita, are you there? Harshita, Dilsha, Vanshika, Pooja, are you all here?
Yes, ma'am.
Who said yes?
Puja, ma'am.
I'm not getting a voice. Pooja, Pooja,
Ma'am,
please
no,
introduce
second.
yourself. Okay, Pooja, please introduce yourself.
Puja Kumar, student of Department of Law, CUT, first semester 11.
BLLB first semester.
No, ma'am, Master of Law, LLM.
Okay, LLM. Okay, okay. Your specialization is Constitution.
Criminal math, criminology.
Okay, okay, okay. Have you enjoyed the lecture?
Yes, ma'am.
Okay, okay. Thank you. Thank you, Pooja. Thank you. Or if anyone would like to, if they may not have any question, but if they are interested, they can introduce.
Ma'am, would you like to continue this session?
Okay, sure.
On behalf of the Department of Law, Central University of Karnataka, and the organizing team of Mission Nyayadrishti Samvad, it is my privilege to deliver the vote of thanks for today's enlightening session. First and foremost, I extend our deepest gratitude to our distinguished speaker, Dr. Juri Goswami, Assistant Professor at JV Law College, Guwahati, Assam. Ma'am, your insightful lecture on a doctrine of occupied field, a critical analysis, has offered us a rich, nuanced understanding and constitutional dynamics and legislative competence. Your clarity of thought, debate of analysis, and academic precision have truly encouraged this lecture series. We are grateful for your time, your expertise, and your valuable contribution to this academic endeavor. Our thanks also go to all faculty members, research scholars, students, and participants for across institutions who joined us today. Your presence, engagement, and thoughtful question added immense value to the interactive segment of the lecture. Finally, a special acknowledgement to the entire organizing committee of Mission Nyayadrishti Samvad for their behind the screen efforts, planning, and commitment that continue to keep this marathon series running successful. Thank you all once again for making today's lecture a memorable and intellectually stimulating session. We look forward to your participation in upcoming lecture of this 100 lecture series. Thank you, ma'am.